With the consent of other side, Lordship, I beg to mention item number 17 and 18, Lord.
17, 18. Okay.
Lord.
You want to adjourn?
Yes.
Mr. S.S. Roy, please for adjournment. And submits that he has taken the consent of the petitioner. Petitioner. Petitioner's counsel. Accordingly, leave this matter
After 4 weeks, Lordship, I have to file
after the vacation.
Lord.
Oh, yeah, yes.
I got my interim order. That can be continued.
Right? Interim order to continue till the until further orders it is there. Then why there's no need. No need, huh?
This matter is listed for execution on 1st of October. This is regarding non-payment of minor fee.
Isn't it?
May it please your lordship. Lordship, in item number 23, we have filed affidavit in additional affidavit, lordship. That may be called for.
History of execution of motion, my lord, next any day. Tuesday.
Okay, Tuesday.
Your lordship was need to fix a writ petition on first, your lord. So I filed an I in that case. That may also kindly be done. What? Madam. Happy you. I get to mention WBC for state was last year of 106. The act was admitted on 17th.
Okay. First. Tuesday.
1st October.
When do you want it? After vacation?
I was expecting 3-4 October.
You want it on 3rd? Why?
Because my senior is available. But as per your convenience,
It will be on 3rd.
much of
Yes, what is your case?
Lordship,
I know. I want her to make submission. Yes, what is your case?
lordship, matter pertains to non-payment of protection bill.
Hmm.
Earlier, the petitioner has approached to the High Court, where the order was passed on 8/4/2021. It's
Ah.
on annexer to page 70.
Ah,
The operative part is on paragraph 4.
ah.
And in the view of the above submissions made by the Learned Counsel for the parties and considering the fact that the respondent number 6 had verified that the petitioner has completed the subject work to the extent of 34.24%, this writ petition is disposed of with the direction to the respondent number 4 to determine the claim of the petitioner in consultation with the respondent number 3. And if such examination, the petitioner is
Yes,
found
what to do? Then on top of this,
Already lease is prepared, my lord. His name is 70.
okay, her name is there. Name is there. At 70?
76.
76.
Already
Then-
annexed.
The name is there in
Lordship, actually, after the writ petition has filed a contempt petition also.
ah,
So in the contempt petition, in the last occasion, the Minister of Operations prepared a consolidated list where his name was in the serial number 76.
yes.
But after that, but till date, nothing has been done.
You
Then
see,
it
madam,
was
you
second-
cannot carry on filing one petition after the other. That contempt petition is still pending.
No, no, your lordship, it has been disposed of. It was disposed of on 8/4/2020. Yes, yes.
Where is
it's on
that?
Page 19, Annexer 3,
It's 19.
Annexer 3.
They submit that. Please read the order. What does it say?
I don't have, because I will keep the update status. Okay.
So this is wrong. This the submissions that have been recorded is wrong. Correct. Please read. What does it say? Page 20.
In the view of the submission, it's by the
Yes, prior to that, what does it say? in the first paragraph.
It's to submit the order to the not part of the supply.
Only list prepared. Like,
So this order is wrong. So you ask for, subject to availability of fund. Where is the new case? I mean, when are you, when are you paying them?
yeah, his name is 76. We have to pay.
His name may be at item one. Have you given the serial number one money till now? You have given?
No, I give update status, my note after week.
You
Only
give,
the
you
previous
give me
process.
the status with regard to serial number one. Has serial number one been paid?
After week,
He is-
my note.
Huh?
The-
You just make a phone call to them. You see, it's very good saying that he's at serial number, so serial number. I want to know if serial number one has been paid. Forget about 76.
I know it is huge exercise. And
Huh?
huge exercise and huge amount of pending levy. That's why.
Mr. Council, your case is that they are going to be paid serially. Correct? You have made a list. When was this list made? When?
2 months ago.
Huh?
I think September, last September, last final list.
When? Last year?
This month.
Sorry.
This month.
This month?
Last list is. Final
When?
list.
Huh?
Final list is prepared this month.
When was it made?
No, the final list is prepared this month.
Which
This-
date?
Date not 4 months.
Mr. Council, I have been seeing this list, I think last month only.
Last month or past week of this. Final preparation. Many lists are published, but it was not.
So you are making one list after the other. Then I think we'll call your secretary. This is not the way. Hurt. What is your name? Oh, your name.
A Sharma on
Miss A. Sharma, Learned Counsel for the petition, who submits that the petitioner's earlier writ petition, that is WPC 3586/2020, for payment of contractual dues had been disposed of by an order dated 8/4/2021, with the direction to the respondents to consider the case of the petitioner and pay the petitioner the admitted amount. The order not being complied with, the petitioner filed contempt case. That is contempt case C-52 of 2022 for non-compliance. No, 22, huh, full stop. The contempt case was disposed of by an order dated 18/3/2024 on the submission made by the counsel for the petitioner and the counsel for the respondent, to the effect that the order dated 8/4/2021 passed in WPC number 3586 of 2020 had been complied with. Next paragraph. The petitioner's counsel submits that the contempt case had been. Why was the 18 March? Why was it closed? It has been complied with. It has been said. Now the petitioner's counsel submits that till date the petitioner has not been paid the admitted amount of rupees
49 lakhs, 84,550.
49,8457. Mr.
RK.
R.K. Mushari, Learned Counsel for the BTC, submits that the BTC has prepared a list of contractors to whom the BTC has to pay the their outstanding contractual dues. And the petitioner is at serial number 76. He submits that the payment to the petitioner shall be paid as the petitioner's name is in the bill. Mr. R.K. Mushahari shall obtain instruction as to when the said list was prepared by the BTC and whether serial number 1 to 5 of the said list as to whether the names of those persons at serial number 1 to 5 of the said list have been paid their contractual due. This is the matter when this is the matter on Thursday. Thursday. In the event of the BTC council not obtaining instructions, the the respondent, the concerned respondent, respondent may be required to appear virtually.
Can be the appropriate fix after vacation.
Oh, okay.
If there is one personal emergency.
Okay, this is the matter after vacation. Don't say all that, huh?
But
Profound apology.
Yes, yes. What do you want to mention?
I have to mention only port number 1 Calvin was
Huh?
I could not come in the mention now. But I have to matter to mention me. Could not come in the mention now.
Ah,
It's extremely urgent, otherwise I would not have made it. May I take the indulgence to make it to subject to lordship convening? And that too for a prayer listing of restoration application at 2 o'clock. Because the railway authority is taking advantage of this and said 2 key units may not. They said remove, demolish everything. But I bow down to that.
okay. We'll see. We'll see.
I'm sorry for that. Right.
Take a seat of your lordship. It's a joint prayer for both of us. Plus, Bijon Das has also given a consent. Okay. That matter which your lordship takes on
Today.
first. First of the body, the
yeah.
oil matter.
Yes, I know.
So we all agree subject to your lordship.
Yes.
That could it be after the vacation?
No problem. No, not an issue.
Also,
7.
7.
Visandas has given a consent.
On
7.
7th of November. No problem. Let it come.
Yes.
Let it come. On that day, we will
Yes.
we just send some of your juniors.
Yes.
And then we'll adjourn the matter on that
Yes.
day. Because now to make a different.
Better.
No problem. Good, you have told me, you have told us in
Yeah.
advance.
That was the reason.
Yes, yes.
I didn't do. I don't want to praise this item.
Acha, one thing, you can send that that adjournment slip to your juniors. One day prior to, say on Monday, please give us the adjournment slip to him, and then it will be done the next.
Don't want to praise this item. Because my lord already contempt petition has been numbered and
Huh?
notice has been issued on the same side. Maybe allowed to.
No, what do you want?
I don't want to praise. But
Oh, you don't want to press. Yes, you should file a contempt.
for
Actually.
undue delay, my lord. Else
Huh?
the contempt petition.
You file a contempt.
Yes, that is my.
Mr. J. Sharma, counsel for the petitioner, says that he may be allowed to withdraw the writ petition. Mr. P. Sharma appears for the Fishery Department, everything. On the prayer of Mr. J. Sharma, counsel for the petitioner, the writ petition dismissed as withdrawn. I'm like.
Your lordships. Lordships, this petition has been directed against the interim order at page 57, lordship. Annex I,
By this order, Lordship, my distributorship has been suspended by the Deputy Commissioner Morigado.
Then you have filed a review, you have filed an
Yes, a
representation
review petition was
for
filed.
review of the order.
Yes, yes.
So that has not been decided.
That has not been decided, and he actually verbally said that he has directed, kindly peruse the page 58, Lord.
Yes.
Page 58, copy 2, hearing at serial 6.
Yes.
Okay. M. Rahman, Assistant Director, so and so, so and so, so and so, for information and necessary action, so and so Morigao is directed to submit the detailed inquiry report on 26/9/2000.
So why are you not waiting for 26?
Your Lordship. Actually, my
What is this? 19, on 19th, a week back, this has happened.
submission
He has asked for a report. That report was submitted probably yesterday. Yesterday is 26. And
is that, Lordship,
when did you file this
it
this
was filed on
petition?
Monday, Lordship. On Monday, Lordship, my submission is that the action of the Deputy Commissioner is beyond jurisdiction, Lordship.
Mr. Counsel, you have filed a review. When did you
Yes.
file the review? On 19th. And
On
you have
19th
filed
because
a,
of 20,
and,
sir.
you have filed a review on 19th,
Lordship.
correct? Or 20, when?
On 20, it was dated at 19.
But 20 you filed.
Yes, sir.
Now, if you have filed on 20,
20.
and you have filed the writ petition on 24, just 4 days later.
And
What is
Lordship,
it?
Lordship,
Uh,
the action of the Deputy Commissioner
you-
is beyond jurisdiction, Lordship. It is the power of the IOCL, Lordship, to take any action. There's clear provision, Lordship. The IOCL is here, Lordship. My senior is here. The senior counsel of IOCL is here.
Now, let us see where is
So,
the,
yeah,
where is
right,
the,
Lordship. Lordship. The state
yes,
of-
what is to be done?
the state authority has no jurisdiction.
Lordship, kindly see page 58, under which action it has taken,
Ha,
Lordship.
ha, ha.
58 page.
Yes, yes,
Assam State Licensing and Control Act, from that we have taken the action.
ha.
That is not applicable in my case
Why?
because Lordship, the petroleum order 2000 is there, Lordship. And this is overriding. effect, Lordship.
Mr. Counsel, when you are, you see, you have filed an you have filed an application for review of the order. Now, what we can do is we can tell the authority to decide it up, because he has asked for a report has come. Now, let it be decided within a week or so.
My submission, Lordship, in this regard, that even if the report is submitted, Lordship, the Deputy Commissioner or the state authority has no power
Okay,
to initiate any action against me, Lordship.
let us see the Assam Trade Articles Licensing and Control Order.
Assam trade article license. This is Lordship, and the license is here, Lordship. License will say.
Mr. Counsel, please understand the question.
Lordship.
Please show me your Assam Trade Articles Licensing and Control Order of 1982. Just show me that. I didn't ask for any other answer. Yes, show me that.
And the provision under which they have initiated action against me is the provision of section 5, Lordship, subsection 1 and 2. As transfers from the impugn order. 5(1)(2) and 10 of Assam Trade Article. 19. Form C.
Why, where does it say that the Deputy Commissioner cannot pass an order?
Yes, Lordship. Lordship, that is the Ministry of Petroleum and Natural Gas Order, New Delhi, 26 April.
Where is it in here in your writ petition?
Lordship,
Where is it in your writ petition?
I have stated. In my report.
Where? Which page? Not, where is the document that you are relying upon in your writ petition?
I am relying upon an order of this court, honorable court, wherein the power of the state authority and the IOCL has been clearly distinguished, Lordship, in the similar cases, Lordship. That is at page 60.
I will
Lordship.
issue notice, that's all.
Lordship,
So let me clarify, but project had actually requested two pieces. Obviously, my method of allotment. Yeah, I will see. It's very less.
Yes, yes. Yes. Actually, this is cancellation of the trade license, correct?
Suspended,
So-
but no notice has been issued, no show of notice is given to me to explain anything. Only relying on a vague report lordship, this has been passed on. This order has been.
Like, matter, my instruction is that they're also perfect to take action, and they're not restrained after public law. Ah, no, no restraint, you take whatever. action.
IOCL can take any action. Any
Actually,
action taken,
actually, why should I close the case? That's not taking. Since he has filed an application for review of the order, and just 4 days later, he files the writ petition. Not even giving time, though knowing fully well that the report was to be submitted last night, and he filed it, that is like yesterday was 26th, and he filed the writ petition 24th. What is this? Right. I will close this writ petition. Heard, mister?
that is it.
That was the learned counsel for the petitioner. Who submit. You have not filed, you have not, acha, this is the case. You have not submitted any synopsis of.
Synopsis is there.
What is this? The list of dates is there.
Synopsis,
Where?
you can't, hospital is there. This is the synopsis. Without synopsis, no finding is expected now.
Acha, okay. Then. I did not find this. So so I had to read the entire thing. Okay. What was it? And Mr. And Mr. What is your name?
That is it.
That was it. Learned counsel for the petitioner. Who submit that the petitioner is a distributor of LPG filled cylinders at Lahore Ghat since 11/6/2014. In terms of the retail license,
State license was issued.
Huh?
The state license is yellow.
where is this retail license?
It is, page 28 lot. Page 28. Is the type.
In terms of the license dated 5/4/2014, issued by the Additional Deputy Commissioner Marigaon under the Assam Trade Articles bracket License and Control bracket Order 1980. So license has been issued by them. They have got the power to cancel.
Lordship,
Then right.
there is distinction lordship.
As well as in terms of the memorandum of agreement executed between the IOCL and the petitioner. The petitioner's case is that the officials of the Food Public Distribution and Consumer Affairs visited the business premises of the petitioner and submitted a report to the deputy commissioner, which resulted in the impugned order dated 19/9/2024 being issued by the office of the deputy district commissioner. Oh, sorry. The impugned order dated 19/9/2024 is to the effect that the inquiry made in respect of the business of distribution of LPG cylinders by the petitioner showed that he had been selling domestic LPG cylinders to unauthorized consumers through unauthorized persons in an illegal manner for illegal monetary gain. And as such contravene the terms and conditions number 5 bracket 1 small one, Roman, and 2 of the trade license issued to the dealer under the provisions of the Assam Trade Articles bracket Licensing and Control Order 1982. Then with clause 10 of the same order and also contravene clause 3 bracket 4 comma 9 bracket D comma, bracket E of the liquefied petroleum gas, bracket regulation of supply and distribution order 2000. Full stop. The action of the petitioner deprived genuine beneficiaries from getting the LP. Full stop. Though the petitioner was directed to submit the complete list of Ujjala beneficiaries, UJJ, UJJAL, beneficiaries within 11/9/2020, the dealer disobeyed the instructions of the licensing authority and thus contravened condition number 10 of the license issued to the dealer. The petitioners trade license number ATA bracket R 7/2014 was accordingly suspended by the impugned order dated 19/9/2020 by the District Commissioner Warrigal under the Assam Trade Articles bracket licensing and control order 1980 and the liquefied petroleum gas bracket regulation of supply and distribution order 2000. The consumers, the LPG consumers under the petitioner were thereafter tagged with MS EVE Dutch Gas Agency Moregal. The petitioner's counsel submits that though the submits that on the basis of the submits that a detailed inquiry report was to be made within 26/9/2024 by the by the assistant by the respondent number is not made them practice
Deputy Commissioner,
by the deputy commissioner's office. Further, though the petitioner has submitted a representation dated 19/9/2024 to the district commissioner Moregal to review the order of suspension of the trade license. And to cause a fresh inquiry of the allegations by an impartial officer. The petitioner. How did it start the sentence? Someone the same not having been done, the petitioner's approach this question. The petitioner's counsel submits that no notice was issued to the petitioner prior to the suspension order being submitted. Yes, Mr. S. Roy, what is
okay,
he further submits that the district commissioner does not have any authority to issue the suspension order in terms of the
in terms of the,
in terms of the 1982 order.
no lordship. Actually, in terms of the Ministry of Petroleum and Natural Gas Order 2000 lordship.
In terms of the Ministry of,
This is,
is that a part? Is that you make it up? We
no
can.
lordship, there is the submission lordship and the copy.
Why don't you annex that or something or put that?
No, the order of
You
the
cannot.
the order of the Honorable High Court actually includes everything lordship. The order annexed to the decision
Ah.
distinguishes the power of the state authority and the
Okay, but
IOC
it has, he has the power under this, Assam trade licenses.
and this order has already effect of upon this order, Lordship. It is to order,
They have suspended the license only, Lordship, not.
plus they cannot take any punitive action against me, Lordship, in terms of the order of 2000 Lord.
Okay, then, anything to say?
Honorable High Court has
As
already
far as, Mr. S. Roy, learned counsel for the petition submit that, and then you say Mr. And Mr. M.K. Chowdhury, the learned senior counsel for the IOCL. I'm sending it back. I'll dispose of the order later.
if the
Next.
judgment at paragraph 22 clearly states
Afterwards. Huh? Let us go to the next. But- Tell him all. Yes.
But the petitioner's license, arms license was cancelled.
Appeal not disposed of.
Not enforced as per the
Dispose of.
They
Will
were
direct them to
disposed of
dispose of.
Yes.
When was the appeal filed?
22, Lordship, page 31. 28/11/2022, page 31.
22.
22. As per the rules, Lordship, it has to be done within 60 days.
As per what rule?
108 of the Armed Rules 2016. 16, Lordship. Please, I have also stated that page number 9. Next page, rule 108. In my grounds also, I
Okay,
have
right. Heard, Mr. B.B. Bora, learned counsel for the petitioner, who submits that that the petitioner's arms license had been revoked by the district magistrate Jorhat by speaking order dated 29/9/2020 for alleged violation of Rule 32 bracket 2 and 10 bracket A bracket B and bracket F of the Armed Rules 2006. The petitioner preferred an appeal under Section 18 of the Arms Act on
29, 28/11, page 31. 28/11/2020, page 30. 30.
on 28/11/2022 before the Upper Assam Commissioner at Jorhat. However, the petitioner's appeal has not been decided till date, which is in violation of Rule 108 of the Armed Rules 2016, which states as follows. Huh? Okay, yeah. The petitioner's counsel submit that the writ petition can be disposed of, if a direction is issued to the
Respondent number 5.
respondent number 5 to take a decision on the petitioner's appeal within a specified time period. Ms. Yudas appearing for all the respondents submit that she has got no objection to the prayer made by the petitioner's counsel in view of Rule 108 of the Armed Rules 2016, which provides for disposal of an appeal within 60 days from the date of receipt of the appeal. In view of the consent of the parties, the writ petition is disposed of with a direction to the respondent number 5 to take a decision on the petitioner's appeal dated 28/11/2022 within a period of 2 weeks from the date of receipt of a copy of this order and a copy of the writ petition. And a copy of the appeal, and a copy of the appeal.
Wait, Lordship, this matter pertains to non-payment of contracted bill matter.
Tell me one thing, your serial number, this 5,
Yes.
is 7 also same thing?
Seven,
Yes,
same,
yes.
same.
Why? How come two
Two
repetitions on the
different
same,
districts, ma'am.
Huh?
Two different districts, ma'am.
two different,
Districts, ma'am. Bongaigaon and Gwalpara.
same amount, exactly same, everything is same.
We have to check on, we'll have to verify.
It's exactly the same. Amount
At this
also
stage, I'm
everything.
paying for notice only.
Huh?
At this stage, I'm paying for notice.
I was just finding it,
Same amount, ma'am.
yes, everything is same.
And-
A number of contract goals also same.
Lordship.
3. Right. Right, Mister?
That's what I got.
Yes, Upadhyay, Learned Counsel for the petitioner who submit that the petitioner's contractual bills have not been paid. You notice returnable in 5 weeks, Miss Udas, accept notice on behalf of
My lord, 1, 2, 4, 5, and 6, free finance, ma'am.
1, 2, 4, 5, and 6. Mr. A. Chaliha, accept notice on behalf of the respondent number 3. This is the matter of 5. To enable the respondents to obtain instructions, file affidavit. Same order, it's 7.
Like-
I did 6.
What to do? Claim for subsidy rejected.
Lordship, if your lordship will come to the appeal order at page 6. This is an order which has been passed in 21.
Huh?
This is an order passed on 9/7/21.
9721.
21. So there is lordship,
Huh?
I would just make a condition that at this stage lordship can only issue the notice.
Correct,
because
correct, that's it.
It's related lordship now.
Okay, right.
3 years.
Dr. B.P. Dodi, Learned Senior Counsel for the petitioner, assisted by Mr. Huh? Enar. The first up. The senior counsel, the learned senior counsel submit that the petitioner's prayer for subsidy slash financial assistance under the Special Purpose Tea Fund Scheme, bracket SPTF, for, by the Tea Board of India. Should be set aside. As the petitioner had completed the field work for replanting slash replacement and uprooting of tea bushes. And as such was entitled to receive the subsidy. Issue notice returnable in 5 weeks, Mr. R. K. D. Chaudhary, Deputy SDI, accept notice on behalf of all the. This is the matter of the 5 weeks, enable him to obtain instructions and file that. Thank you very much, Obedi. Yes, what is to be done here?
With direction to the superintendent DMCH to constitute a medical board and accordingly issue disability certificate.
If he's
If he is disabled,
eligible,
first constitute a medical board, then
okay, right, but Mr.
And so.
M. Right. This item, M. Like that. Learned counsel for the petitioner. To submit that the petitioner had prayed for issuance of a disability certificate under the Assam Right to Public Service Act 2012, hereinafter referred to as the Act. Due to the petitioner's left hand having become paralyzed in relation to an accident, vehicular accident arising out of Kaliabor PS case number 19/2023 under section 279 /T838 /T04 bracket A of the IP. The petitioner's counsel submits that the petitioner is in need of the disability certificate for what purpose?
Locomotor disability.
No, for what purpose do you need the
So now
certificate?
it will be requiring to submit
For-
as evidence of the before the MSC.
For-
tribunal.
Okay, for making a claim. For
Yes.
making a claim. For compensation before the Senate
MSC
Motor Accident Claims Tribunal
at Kamloops Metro.
in Kamloops. He submits that despite the prayer of the petitioner being made to whom did you make a prayer? To the Joint Director of Health,
Director,
Kamat Darang,
Darang,
Darang District.
Darang.
No action has been taken by the concerned.
Durham district, there is no legal expert. Therefore,
No, that is his submission.
yes,
No action is being taken by the uh, Joint Director Darang. Miss
yes, sir.
S. Sharma, the learned
Standing
Counsel for-
counsel head.
Standing Counsel Health Department, and Ms. appearing for Spencer, and Mr. S.R. Barwa for Ms. D. Jade for Spencer, and S.R. Barwa for respond number 3. Submit that the writ petition can be disposed of if a direction is issued to the
GMCH superintendent,
superintendent,
Guwahati Medical College.
GMCA,
Yes.
Guwahati, bracket respond number 4,
Four.
to constitute a medical board and to examine the petitioner's injury. If the petitioner is eligible to be given a disability certificate, the same can be given on the basis of the report made by the medical. Ms. S. Sharma also submits that the Joint Director Darang District could not pass any orders in respect of the claim of in respect of the prayer of the petitioner, in view of the fact that there was no medical expert. Medical neuro expert.
And
Neuro expert or neurosurgeon or what?
neurosurgeon, neuromedicine also.
There was no neuro expert in the Darang District to examine the petition. Next up. In view of the submissions made by the council for the response. This writ petition is being disposed of with the direction to the respondent number 4 to constitute a medical board within a period of
4 weeks.
4 weeks from the date of receipt of a copy of the order. The medical board shall thereafter examine the petitioner, and if it is found that the petitioner is eligible to be issued a disability certificate, the same will be issued to the petitioner.
Thank you.
Matter relates to non-payment of contractual skill matter. At least I am paying for issuing notice matter and then.
What about security deposit?
Yes, madam, because whenever payment is paid for 10% security will be deducted matter at the time of payment matter. Out of 4 bills, she have been paid, keeping 10% deducted matter. That also has not been, within 6 months, they have to give matter. As per clause 9, they have to give 10%, they have to release it matter within 6 months. That also not been done.
Third, Mr.
As Mukhtar matter.
S. Mukhtar, learned counsel for the petitioner who submit that the petitioner's contractual dues and security deposit have not been released.
And also one bill
Have
payment
not
also.
been paid, have not been paid to the petitioner.
One bill also not paid and three.
I said contractual dues.
Yes, yes.
Cover
madam.
everything. Issue notice returnable in 5 weeks, Mr. Okay,
No, but
Ah.
notice will go, madam.
Huh?
Notice, nobody appeared, no standing council, madam. The government of Assam undertaking, madam. Will take steps, madam.
Okay, petitioner takes steps for service of notice upon the respondent by registered post with AD within 3 days. This is the matter after 5 weeks.
Pendency shall not be barred.
Pendency of the writ petition shall not be a bar for the respondent to make payment of the dues for the petition.
Okay.
No one appears for the petition on call. This is the matter. This is a motion. In the next week.
Existing question regarding distinct and separate legal entities liable for your lordship's consideration. A request inviting expression of interest for consultancy service for design, management and supervision consultant for Southeast Guwahati Water Supply Project, page 65, my lord. Was issued. This is the process of shortlisting 3 to 6 bidder who will then thereafter respond to the RPF. Your lordship, just have a look at page 65. This is my lord. The request for expression of interest, selection of consulting services for design, management and supervision consulting. DMSC, my
Yes.
lord. And your lordship, the relevant part, your lordship, 68 would, my lord, the nature of the project is mentioned. And really, my lord, your lordship comes to the relevant provision at 77. 3.2 is the eligibility condition.
Design management of what?
My lord, there will be a water supply scheme.
Water
which is
supply.
To be introduced in Southeast Guwahati for 24-hour potable water. For these are the consultants who are appointed
Okay,
to
yes.
assist in the
Okay.
project implementation.
Yes.
Now, 3.2, my lord, the eligibility and qualification, there is no dispute, we fulfill it.
Page 78.
77, my lord, 3.2. Purpose is, my lord, may I read from 3.1?
Yes.
Purpose of this EOI is to shortlist qualified applicants as per the eligibility criteria for providing design, management and supervision consulting services for Southeast Guwahati water supply projects under AUIIP 2 after completion of the EOI process for shortlisting. The procuring entity shall issue RPF request for proposal to the shortlisted applicants, requesting them to submit detailed proposal, financial and technical as per RPF terms and condition RPF stage. In the RPF stage, the most eligible among the shortlisted consultant would be selected for award of contract based on the evaluation of the proposal submitted by as per the RPF terms and conditions. 3.2 is the eligibility criteria. There is no dispute. The bidders fulfill it, but there are some other problems which I'll allude to your lordship. This is really, my lord, shortlisting process. 3.4, my lord.
3.4.
4, my lord. Checklist for EOI submission and 2, if your lordship turns, serial number 5. Declaration with respect to non-blacklisting and debarment in a non-judicial stamped paper duly notarized as per the format given in Annexure 5, which your lordship will find at page 87.
Page 87.
87. So this is the.
No, you should not be blacklisted. You should not have been blacklisted.
No, I am blacklisted because, my lord, certain associate companies of the parent.
Two associate companies.
Of the parent company, they have been blacklisted. So, my lord, the whole issue is very, and your lord, the language is very clear in this affidavit, if your lordship sees. My lord, Roman 1, we, that is the bidders, or any of our promoters, directors, partners are not blacklisted or otherwise disqualified pursuant to any department proceeding by any central or state government, local authority, or public sector undertaking in India, because all these blacklisting is outside India, my lord, of the two associate companies, from participating in any bidding process, either individually or as a member of the consortium. And so far as a false statement also, if your lordship sees Roman 3, we or any of our promoter, director, partner, and officer are not convicted of any criminal offenses related to their professional conduct or the making of false statement or misrepresentation as to their qualification to enter into procurement contract within a period of 3 years preceding the commencement of procurement process. If your lordship sees at page 81, the covering letter, also similar indications are there.
81.
81, this is the covering letter, and at 82, foot of page 82. It's similar to 87. Your lordship, the second last paragraph, we undertake that we have not been debarred or blacklisted by any government, central, state, agency, or PSU and fulfilled it right. The whole intention was restricting it within the jurisdiction of our country. And if your lordships come back to page 79, they've been very clear, assessment will be as per your qualification, not your parent company subsidiary. Just after the table at 79, my lord. My lord has stated the experience of a parent company, subsidiary company, group company, or associate, whatever the name of the applicant, shall not be considered for evaluation. So, if I can't take their credentials, I should not be also victimized because of that, my lord. And my lord, these, my lord, so far, P1 really.
You have been blacklisted abroad, you mean, not in India.
What has happened if your lordship sees page 20, we have explained.
No, you were just saying that you have been.
My lord, there is one parent company, French company, Egid SA. That is the main company in France. The petitioner number 1 is a private limited company incorporated under the Companies Act. 99% is owned by that Egis SAU. Now, the second petitioner is a foreign company that is incorporated in France, but registered in India and which is permissible under 242 of the Companies Act. Petitioner number 1 is in India, operating since 95, incorporated in 2005. It has carried out many projects. Now, what happens is that parent company has associate companies. It's like Tata Sons, my lord, is the parent company. They have Tata Chemicals, Tata Coffee, Tata Tea. Now, what has happened is the Tata Tea has been blacklisted. Now, Tata Chemical has submitted its bid in a particular project. So, Tata Chemical is being denied and declared ineligible because Tata Tea has been declared blacklisted. This is, my lords, in the domestic, but this is a multinational. So, it is, my lords, the 2 associate companies in Panama. World Bank has, but there is no cross shareholding. Our shareholding, P1 is concerned, is fully owned 99% by the parent company, which is not blacklisted, 1% by another company, not blacklisted. I'm really concerned, my lord, with P1 because there's some problem for P2. P2, my lord, is a French company, but still it doesn't have so much link with the blacklisted company, except that it had purchased a business of one of the blacklisted company, P2, that we have in our representation.
So that means one of the directors here, they are directors.
No
they are not-
directors. Because these are all group companies, the water and sanitation unit has been purchased over. Separate company, but within the group, their, my lord, interrelated business agreement has been. And that is all prior to the tender. The lifting the wheel is the only exception, my lord, of the separate and distinct is in case of exceptional circumstances of fraud, when it was a whole camouflage. But here, my lord, P1, if your lordship sees the credentials we have stated in the writ petition, they have been in India. It's a private limited company. It has carried out many government projects which have been awarded. So P1 is absolutely clean. Somebody, my lord, may poke a finger on P2, but That is because only thing is because they had purchased in our representation.
But why is that, why you mixing up these two companies here, P1,
Actually, the bidder had three joint venture because my lord, it requires certain credentials. It is permissible under the.
So this is a joint venture
It
between.
is a joint venture. My lord, no, I'm coming to the real problem, my lord. Otherwise in law, my lord, the Punjab and Haryana High Court, and your lordship knows, my lord, this Fox and King and.
No, I don't know anything. You'll have to, I have to be.
No,
Who's
that's
that?
why we place it, my lord. I know your lordship knows, but still will place it, my lord. Your lordship would now see, my lord, this is the tender process. It is clear that department must be via a central or a state POC or in India. Now we participated so far as my P1 is concerned. If your lordship 61, just to place 61, if your lordship sees, this is the P1. It is an incorporated company under the Companies Act. It's incorporated under the Companies Act, 861, my lord.
Yes.
This is Edges India Consulting Engineers Private Limited. 3/2/2005 is the date of incorporation, and it's a private limited company. And my lord, the shareholdings for this company, your lordship will get at page 88. Page 61 is the Ministry of Corporate Affairs. So it is in my lord, incorporated.
88.
88 is it's part of the audited balance sheet. Page 88 is your lordship. See, Edges India Consultant Engineer Private Limited. Page 88. Somewhere in the middle, my lord, your lordship sees Edges Engineering France, the holding company. They hold, my lord, 99%, and there is one IPS France.
Where is this 99?
Somewhere in the middle of, my lord, somewhere. It's shares held by holding an ultimate holding company in the middle. You're under that heading. Your lordship at page 88.
99%. Yes.
99. The other is
99.99%.
the other is one share by this
That-
IPS France. I don't know, my lord.
Huh?
The other is IPS France. If your lordship sees after Edges Engineering, there is another company, IPS France. They hold one share. So two French companies which are not blacklisted, admittedly, my lord. They are
Just a minute. 118,
88, my lord.
180, 1. Oh, where does it say? This 99% is.
So far as Edges Engineering is concerned, holding company, if your lordship, just the last paragraph.
Yeah.
Percentage of total shares 99.9%. 99%.
Yeah.
And this IPS France, little above, my lord, if your lordship notices that IPS France, it has one share. So there are two French companies who holds 100% share in this private limited company. This is qua, my lord, the petitioner number 1. Now, the petitioner number 2, my lord. Is page 63.
63.
63. Well, under 242 of the Companies Act, a company incorporated outside India, if it wants to carry on business in India, it has to register itself under 240. So in terms thereof, the Ministry of Corporate Affairs, therefore, my lord, there is definition of foreign company fulfills that. Foreign company information, Edges Water and Maritime SAS. ROC Delhi, it was incorporated in 23/9/21. And if your lordship sees, it is a branch office in India, real estate renting. And if your lordship sees at page 90, my lord, that we have ever, these documents don't get, but it's 100% shares are held by this company by the name at 90, Edges Holding Environment Structure. And all these, my lords,
So this petitioner Is edges, one is edges, and the other one is also edges.
Edges, my lord, they are, because the parent company is like Tata, my lord,
Ah.
Edges. So they have, the second, third names are different. And ultimate holding company, your lordship, that name your lordship will find at page 89. Is if your lordship sees at page 89 somewhere in the description of relation, A, ultimate holding company, Edges SA France. At page 89. In the middle, related party disclosure, and A, if your lordship sees, it's not so clear. Ultimate holding company,
Okay, this
Edges
is
SA
ultimate.
France. So this is, my lord, the parent like Tata Sons, my lord, and the whole problem is because they control all these companies as well as those depart companies in Panama. This is, my lord. Now, my
No,
lord,
but who controls the depart company in Panama? This, the parent
that
company?
we have, that shareholding we have placed, your lordship will have that at page 19 of the writ petition. Sorry, page 21 of the.
No. You see, those depart companies, they are being controlled by this parent company.
Parent company.
So this petitioner one and two are not having any,
With
link
the
with
depart
that.
company, there is
Yeah.
no cross.
the link is only through the parent company.
Parent company, I can't deny the fact. It's like my Tata Sons is controlling so many Tata company. But that doesn't mean that if one Tata company, because separate legal entity is the very concept, my lord. Otherwise, it will create many disastrous consequences. Now, so far as the two depart companies at page 21. After the chart, my lord,
Page 21.
21. What shift has
Yes.
fine. As is evident from chart C1 above, the ownership of depart entities is as follows. Aegis International SAS is owned by Aegis Root Creatorate SAS 63% and Aegis SA 39%. And this Aegis Root Creator SAS is also fully owned by SAS. There is no denying the fact that it is controlled by Aegis SA, but the bidders have nothing to do with this company, nor these companies have anything to do with.
No, what is this company at the bottom? It is international. It is international.
There are two depart companies, my lord.
Ah,
First is Aegis International SAS.
yes.
It's a French company.
And where is the second
And
one?
we are giving the shareholding also. And the second is Aegis EAU SAS, fully owned by Aegis SA. Aegis SA is the like Tata Sons, my lord.
Okay, so this
So there
it
is
is
no-
EAU SAS and it is international SAS.
My lord, my lord, my lord.
So this okay, both of them, they are the blacklisted company.
These are the blacklisted, which I have explained.
And where is the petitioner?
That is page 22. What I have to the documents I have now explained in the.
Why were they made into this chart?
The chart is so confusing. So 22 is a better, my lord. So
22. Yes.
what I have indicated to the documents is mentioned here. On the other hand, ownership of the petitioner is as followed, my lord, as at page 22.
Yes. Yes.
These are the two bidders, Aegis India Consulting Engineers Private Limited, that is P1, lead bidder. The lordship may note, my lord, page 63 and 88 are the documents which I have shown relating to this company. Is owned by IPS SAS 001% and Aegis Engineer SAS 99.99%. Both IPS SAS and Aegis Engineer SAS are fully owned by Aegis SA. Then the other company, Aegis Water and Maritime SA.
No, just a minute.
Fine.
This Aegis India Consulting, this is petitioner number 1.
Fine.
Which is owned by
These two companies.
okay, IPS and this
And Aegis
Water, Aegis Water Maritime is the petitioner number 2.
They are held by Aegis Holding Environment Structure SAS which is eventually owned by Aegis. Your Lordship may just note the pages which I have already placed so far as your Lordship is located. So there is no cross shareholding is what I'm saying, that they are independent entities. And these are these are all, my lords. What is it called? In what bank is it? These are all new development bank funded. So when they frame tender condition, they consult everyone. They consciously put the condition that department must be by a central or state agency or any other in India. For whatever be the reason, that is their conscious decision.
So your submission is basically, one is that blacklisting is done outside India.
Ah.
So it cannot be applied to this case. Secondly, even if blacklisting was to be considered as being applicable to India, then also they being a different entity in terms of the shareholding, uh, that clause would not affect.
Right.
That's all.
That's it. But I must tell you, Lordship, that the date of bidding is expired on 11th of September 24.
Then
So they are under consideration, but I have to be fair to your Lordship, now.
11 September,
That your Lordship is
that's the last date.
my lord. Then
And it is what? It is a 2-bit system, 3-bit. What is
that is,
it?
after shortlisting, the May, June, July, this process, page 54, ultimately your Lordship is the impugned order at page 54, which they say is the reasoning, which my lord is totally, we are really aggrieved by the reasoning. Page 54. Ninth of July 24.
Yes.
Response. After detailed review of the representations received, the following points are responded. The firm Aegis International SA and Aegis EAU SAS are marked as crossed the bar in World Bank listing of ineligible firms. Further, the registered office address marked in the bank.
In World Bank listing. So it's not by the state.
No, it is not, because they are funding these foreign bankers, all they are funding, so they are consulting, the World Bank also is involved. There are big companies, 4 or 5 banks, Asian Development, they are funding all these projects, my lord. That is why their involvement, because if your lordship sees the 3
So but then the World Bank has barred you.
they could have had a framing of the expression of interest. When you frame that, you should have consulted your lenders and frame the terms accordingly. After,
But who is going to fund this project?
this is by New Development Bank, it is a foreign lender, that your expression.
So will that new development bank come within this World Bank listing? Yes.
Because they are, my lord, they work in tandem. Your
Then-
lordship is absolutely right. These are, your lordship would see, I just tell your lordship, it's how they, that there is that. Page. These banks we have described, man. If your lordship sees page 18, this cross, what happens is if one of these lenders debar an entity, the others follow suit. Because they are the group funding in various big countries.
Then how does it help you to find, unless you make them parties or something?
No, my lord, they could not, their clause. What I am saying, while framing, you should have consulted them. After framing the clause so clearly, now you can't say you go and they take their advice. The time for seeking advice was before framing of the expression of interest.
No, but then.
You have to be bound, you're bound
Now, if you are barred, either by the lenders, by the persons who are going to,
outside India, my lord.
whatever it may be. They have got their, they are the ones who are going to fund the project wherever it may be. It might be in Jamaica that you are in blacklisted, but
They could have then, why did they expressly put that your blacklisting must be in India? This is a public invitation. This authority respondent number
But then
two-
you said that the banks that are going to fund the project here, they are the ones who are part of,
No, their advisor sought. That is what I'm saying. That their advisor time for it was prior to the issuance of the expression of interest. Once you put it in public domain, you have to be bound. You are guided by the terms and conditions. The terms and conditions are absolutely clear. The debarment will happen only if any of your director or the bidder is blacklisted by a central or state agency and in India, which is absent in this case, page 87, if your lordship sees. The two indication, 81 and 87, it's not like it's a slip. 87 again, if your lordship sees, this is the real provision for blacklisting. They have been pragmatic. The project implementing agency have been, because to do these kind of work, you need large entities, my lord. They may have taken a conscious decision, knowing the ground reality, and they have to now stick to this.
but supposing the state of Assam says, okay, you are selected or you are in the consideration, then these sponsors of the project, they'll back out. They said, how can we deal with this person?
Right? That is why I'm submitting that. The claiming, if the request for EOI is an important facet of the case. It also must have been deliberation, consultation. You don't come up with these kind of expression of interest without application of mind, without, if your lordship sees the expression. At 87, your lordship sees, your lordship knows that my lord, the blacklisting, this is the only provision in that so-called my lord request for expression of interest. And there they have, it's a restrictive covenant, my lord. And we, my lord, we means who, my lord? Obviously the bidders.
So this World Bank's listing will
What
include
happens is the first, my lord, we change the three impugned decision. First, they are unsure. I'll show your lordship. So they say, let's consult the World Bank. Then the directive comes from the World Bank and that results in rejection of our representation in 54, which I am submitting, my lord, is totally inconsistent with settled legal principle that each legal company has a separate and distinct entity except the exceptional circumstances being lifting of the veil, which is not, cannot be a case here. I've been operating from, it is not as if these companies were formed to do this business as a cloak for somebody who's already blacklisted. Those Panama companies are not interested in doing work. There is no suggestion that as a cloak, I am in existence since 2005. It's a private limited company incorporated in India. I am interested in doing work in India. I have done about 90 projects. I have been given award. Today, I have been put in a difficulty, and what is really troubling is more than this project, my lord. This will have spiraling effect, my lord.
naturally.
I thought that therefore the legality of the
But the spiraling effect had already started from before.
date is rest. No, till now, that's why your lordship would see the credentials of P1 and P2. Your lordship, the writ petitions we have ever that page 10 onwards, my lord. It's not a company which has just come to India.
So what do you want right now?
Right now, I want to be my lord because I can also see, my lord, that I would have submitted that your lordship would permit me to participate in the process because the process is ongoing. And I was within they had to shortlist 6. I was assessed. I was 5th. Your lordship would see that at page. It is not as if I have been assessed on merit. That your lordship will find at page 50. Under the tender clause, you have to shortlist between 3 and maximum 6. I came 5th. That your lordship will find at page 50. Paragraph 5. It is India Consult, 37 points. I was 5th. So I was within the shortlisted. I could have been my lord, and they have ultimately recommended people below me. The first and the fifth have been disqualified. Therefore, they have gone up to 7 Tata Consulting. Oh, no, actually 8. Were forced.
So,
My lord,
so what do you want right
that,
now?
that I'm coming to, my lord. That because, my lord, P1 is a company which your lordships will see, I just wanted to show their credentials. Para, para 7 onward, at page 10. And really at 8 onwards, my lord. There are so many projects and 90 successful projects have been. Today, my lord, I want this, my lord. One is, I would have, my lord, could have, my lord, that your lordship would be kind enough to permit me to participate, but there is some problem in subsequent development who are people. So therefore, my lord, I have to be fair to your lordship. But P1 is an entity which has good track record in India since 95, incorporated in 2005, successfully carried out 90 projects in these infrastructure projects. I am praying, my lord, that the impugned order be stayed at least qua P1, so that in some other project, this does not come in my way. That is what, my lord. And the Punjab Haryana High Court, similar things happen. And Cox and Kings is, my lord, the relevant part, my lord. I can just, because our representation contains that, your lordship would just have a look. I can place the judgment also, but it's the quoted part is also there. Otherwise, my lord, 120 Vodafone or my mark. This is the Punjab. Page 88 onwards, this is, my lord, the group company doctrine regarding arbitration that we have discussed on separate legal entity. Your lordship would come. Page, paragraph 87 at page,
There is no page.
that is para 87, my lord. Page 62, but it's funny.
Para 87.
My lord.
Okay, yes. Para 87.
May I have, my lord?
Yeah.
It's under the heading Group of Companies Doctrine, correct, separate legal entity. The phenomena of group companies is the modern reality of economic life and business organization. Group companies are set as separate firms linked together in a formal or informal structure under the control of a parent company. The group companies can be defined in the Indian context as agglomeration of privately held and publicly traded firms operating in different lines of business, each of which is incorporated as a separate legal entity, but which are collectively under the entrepreneurial, financial, and strategic control of the common authority, typically a family, and are linked by trust-based relationship forged around a similar persona, ethnicity, or community. A group company involving the parent and subsidiary company is created for myriad reasons, such as limiting the liability of the parent corporation, facilitating international trade, entering into business ventures with investors, establishing domestic corporate residence, and avoiding tax liability. The principle of separate legal personality has been the cornerstone of corporate law. In Aaron versus Salomon, Popper was Ray Salomon, the House of Lords famously observed that a company at law is a different person altogether from the promoters, directors, shareholders, and employees. The principle of separate legal personality equally applies to corporate groups. A parent company is not generally held liable for actions of the subsidiary company of which it is a direct and indirect shareholder. The Companies Act 2013 has statutorily recognized a subsidiary company as a separate legal entity. 246 of the Companies Act defines holding company as these are the provisions of the Companies Act, but if your lordship comes to para 89, a bench of 3 judges of this court in Vodafone International Holdings BV with the Union of India emphasized the principle of corporate separateness in the following terms. A company is a separate legal persona and the fact that all its shares are owned by one person or by a parent company has nothing to do with its separate legal existence. If the owned company is wound up, the liquidator and not its parent company would get hold of the assets of the subsidiary. None of the authorities have the assets of the subsidiaries have been held to be those of the parent company unless it is acting as an agent. Thus, even though a subsidiary may normally comply with the request of a parent company, it is not just a puppet of a parent company. The difference between having power or having persuasive difference is between having power or having persuasive position. Though it may be advantageous for parent and subsidiary companies to work as a group, each subsidiary will look to see whether they are separate commercial interests which should be guarded. The separateness of corporate personality will be ignored. This is the only. I should know this, my lord. No, I don't know. Please, I can, my lord, skip these paragraphs and come, my lord, to para 24.
This personality.
My lord, will be ignored. This
by
is
court.
except in exceptional situations where the company is used as a means by the members and shareholders to carry out fraud or to evade tax liability. If a court, on the basis of factual evidence, determines that the company was acting as an agent of the member or shareholder, it will ignore the separate legal personality of the company to attribute liability to the individual. This is, my lord, the only exception, that if it is acting as a cloak. And then your ultimate finding is at para 94. From the above discussion, we can
What about 91?
companies. There may arise situation where the holding company completely dominates the affairs of the subsidiary company to the extent of misusing its control or to avoid concealed liability. So element of fraud is the requirement to pierce the wheel, my lord. In such situation, the court apply the doctrine of alter ego or piercing the corporate wheel to disregard the corporate separateness between two companies and treat them as a single entity. In LIC versus Escort, the constitutional bench of this court noted that the principle of distinct legal personality may be ignored where the associate companies are inextricably connected as to be in reality part of the concern. Speaking for the bench, O. Chinnappa Reddy Justice observed, generally and broadly speaking, we may say that the corporate wheel may be lifted where the statute itself contemplates lifting the wheel or fraud or improper conduct is intended to be prevented or a taxing statute or beneficent statute is sought to be evaded or where associate companies are inextricably connected so as to be in reality part of the concern. It is neither necessary nor desirable to enumerate the class of cases where the lifting of wheel is permissible, since there must be necessarily depend upon the relevant statutory or other provision. The object sought to be achieved and impugn conduct and the involvement of the element of public interest, the effect on parties which may be affected. The separateness of doctrine of lifting, the application of doctrine of lifting the corporate wheel rests on the overriding consideration of justice and equity. Often the court pierces the corporate wheel when maintaining the separateness of corporate personalities found opposed to justice, convenience, and public interest. In Balwant Rai Saluja versus Air India, this court cautioned against the principle of piercing the corporate wheel should be applied in a restrictive manner and only in scenarios where it is evident that the subsidiary company was a mere camouflage deliberately created by the holding company for purpose of avoiding liability. It was further observed that the intent of piercing the corporate wheel must be such that it would seek to remedy the wrong done by the holding company. In the context of arbitration, The principle of piercing the corporate veil has been sparingly used because it disregards the intentional parties by emphasizing on the overriding consideration of good faith and equity to bind the non-signatory to an arbitration agreement. Moreover, since companies in a group have separate legal personality, the presence of common shareholders or directors cannot lead to the conclusion that the subsidiary company would be bound by the act of the holding company. The statements or representation made by the promoters or directors in their personal capacity would not bind a company. Similarly, the mere fact that two companies have common shareholders or common board of directors will not constitute a sufficient ground to conclude that they are a single economic entity. The single economic entity or the single economic unit theory imposes the general enterprise liability on the corporate group. In so and so, Lord Denning held that a group of three companies should be treated as a single economic entity on the basis of two factors. First, the parent company owned all the share of the subsidiary company to the extent that it controlled every movement of the subsidiary company. And second, all the three companies in a group virtually acted as partners and not to be treated separately. Thus, the determination of whether two or more companies constitute a single economic entity depend upon the concerted effort of the companies to act in pursuance of common endeavor or the enterprise. From the above discussion, we can infer that entities within a corporate group have separate legal personality, which cannot be ignored, save in exceptional circumstances such as fraud. The distinction between a parent company and its subsidiary is fundamental and cannot be easily abridged by taking recourse to economic convenience. Legally, the rights and liabilities of a parent company cannot be transferred to a subsidiary company and vice versa unless there is strong legal basis for doing it. Kind of piercing the veil because the divide company and the bidding company have no association. The only common factor that it is controlled by a common parent company. Otherwise, they have nothing to do our business in India. They are operating in elsewhere in Panama. So the exception circumstances where you can invoke the doctrine of piercing the veil is also absent in the fact circumstances of this case. In a similar case in Punjab, my lord. Yes, my lord. I just, my lord, para 4 poses the question. We must proceed, my lord. Therefore, on the basis that SIF Private Limited, as on date, stands blacklisted, and the directors of SIF Private Limited and the petitioners are the same. The question that arises for consideration is whether the petitioner can be deemed to have been blacklisted or to be blacklisted without applying without anything more by reason of the fact that the only directors of SIF Private Limited are also the only directors of the petitioner company. You'll also come to the relevant paragraph. One. Paragraph 8. The same. Paragraph 8, my lord. The petitioners and Messrs. SIF Private Limited are separate legal entities. The fact that the directors of the two companies are the same does not make any difference. They still have separate legal entities. Whether the corporate veil ought to be lifted or not is a different matter altogether. We do not suggest that in cases of blacklisting, the corporate veil can never be lifted. If, for instance, The purpose of incorporating a separate legal entity is to circumvent an order of blacklisting. Even if in anticipation, it may well be possible for the party inviting tender to lift the corporate green and avoid such circumvention. They will, however, be on account of incorporation being founded in deceit and fraudulence. The existence of common directors may even warrant the lifting of a corporate bill in an action for winding up the company on the ground that the company incorporated under the Companies Act is nothing but a glorified partnership. That is a different matter. However, the mere fact that the same persons promote, incorporate different companies would not entitle a party inviting tenders to paint each of them with the same brush by deeming the associate or sister concern to be blacklisted merely on account of one of the group companies being blacklisted. Such a view would have disastrous consequences upon the group companies, especially upon larger groups. There is no warrant for deeming all the companies in a group to be blacklisted on account of one of the group companies being blacklisted. Paragraph 9, man. I just want to be somewhere in the middle, man. Parties are entitled to arrange their business affairs in a manner permissible in law. One of the methods is by incorporating different companies. A web of companies is not unknown to corporate law, and the corporate world often resorts to the same for a variety of reasons. The incorporation of separate legal entities, even by the same promoter, does not necessarily imply a fraudulent intention. This being so, it follows that blacklisting of one company does not lead to blacklisting of its associate and sister companies, however closely related they may be. And they say, my lord, if you want,
Those are, that's
my lord,
the,
these are known principles.
no,
my lord.
no, but the issue is now, so the Black World Bank,
No, look, by the respondent number 2, page.
no, yes, but
Then
because
on the
of that,
advice, Your
yes.
lordship may just have a look at 54. This portion is what I'm saying, my lord, because this will have spiraling effect in other projects.
Yes.
Madam, page. After detailed review of the representation received, the following points are responded. The firm Aegis International SAS and Aegis EAU SAS marked as cross debarred in World Bank listing of ineligible firms. Further, the registered office address marked in the bank's website is that the registered address of the specific firm submitting EOI, Aegis Water Maritime SA. So P2 shares the same address with the debarred company. The second point, my lord, further based on document, my lord B, submitted, it is observed that the ownership and control of bidding participants, that is Aegis Water and Maritime SAS, as well as the cross-debarred entities, Aegis International SAS, Aegis EAU SAS, is with Aegis SA, indicating common control and ownership. This, my lord, your lordship's age is not sufficient to say, my lord, that the sister concern would be. And really, if this order is directed against P2, today I am making a limited prayer that so far as P1 is concerned, which is an incorporated private limited company in India, and in existence incorporated in 2005, operating since 95, have carried out close to 90 projects. They have nothing to do with these blacklisted companies. Neither they share any registered office, nor there is cross shareholding, at least so far as P1 is concerned. I'm praying your lordship may stay the operation of this page 50 for observation at the moment. That is what I DPO.
So we have to unveil what exactly is the intention of this case. They are actually challenging the order dated 5/7/24 at page 54. Whether that is under challenge or they are challenging something else, which they are not coming up in clear terms. We are not the authority who have blacklisted. So first, if they are really aggrieved by the process undertaken by the state government authority and its agencies, whether in these proceedings, Lordship's observation which they are praying now can be granted. Because the actual parties who can give light to the allegations of blacklisting or what are the shareholding, all these permutations, combinations, Lordship, we are not the competent authority, neither we are interested also. So my first submission would be, Lordship, this litigation is not maintainable because P1 and P2 are standing on different footing. P1's 99% shareholding belongs to that French company who is already blacklisted by World Bank. And so far as P2,
No, the company that is blacklisted. It's some.
that this is his first submission, that P1, the parent company
Not the
who has
blacklisted.
99% shareholding in P1, they are blacklisted.
No.
Anyway,
That is not it.
number one, the parent company is blacklisted for both the companies. That they agree, but that we also have the record. And so far as P2 is concerned, they were also blacklisted on 24th of September.
Where?
I have the document. They may not be, they are not disclosing all the facts. Whatever facts we have, I have from Ritika. So number one, both P1 and P2 are on different footing. So this petition is not maintainable on that ground because their standing is different. The locus is different for both the cases. Number two, if they are aggrieved by our shortlisting of 6 firms, then they should be made parties here. Because if their main prayer is that they should be considered for providing the various dates or whatever is invited, then Lordship, somebody one out of 6 will
They
have
will
to
have
give
to,
way
they have to give way.
one way. Number two, so those are not parties. So, and number three, the respondent number 1, there is no such department as Guwahati Development Department for last 3 years. And that can be very well visible from page 54, the impugned order.
What is development?
Yeah, there is no such development department. There is a totally new department, which is there at page 54, will can come, which is the impugned notification. Copy has been marked with down below, okay?
Yeah.
The government of Assam, Dohua. Dohua is Department of Housing and Urban Affairs. So that is the actual department which they have to implement. This is number 4. The impugned order was issued on 9/7/2024. Now we are entering October. There's a huge delay. If my submission is on 15th of July, the 6 shortlisted companies were announced.
Okay. 16th of July.
15th of July.
15th of.
So that is not put to challenge. It is available in the website. I have the copy of that. So from all this point, Lordship, at this stage, this petition is not maintainable. Non-joiner of necessary parties, not joiner of wrong parties.
That,
So I think you are
Only
only
notice may
right
be
now.
issued at this stage.
Only notice.
Only
but
notice without any
also will not-
observation.
Notice also will not serve its purpose. Because if they have already selected.
Just
Sorry,
wait and
I
complete.
I quite see coming in after the final latest, that's why I'm not pressing for my love that I should be permitted to participate because the P2 also has its own problem. I am therefore pressing for only that so far as.
No, there's no question. There's no question now for giving a say
No, I'm,
or allowing you to participate.
no, I
You are-
don't know, I'm not pressing for that, my lord, that I'm not.
That is
pressing.
why my
And
submission is
so far as selected candidate is concerned, because it is still in the process, we don't know who will be the ultimate selected.
Correct, but then,
Arraying them as
but
a
then-
party may not be required.
no, but then at the same time, if they are already 6. And at the time of whenever we are going to take a decision, then they will have to be made a part.
His name also will have to, I can't ask you otherwise.
You actually, I also find it quite reasonable. And the submission made by the AG. To the effect that, maybe you need 2 repetitions, not 1.
And because of this, because it happened subsequent to the,
You
filing.
need 2.
20.
So,
not 24. The petition, I think, was filed on 27.
they were instructed same day, I think, same.
Anyway, this is on
That time, my lord, your lordship is absolutely right, that I can quite see, that is why I'm not pressing that also. My lord, your lordship may then only issue notice at the moment.
but what is,
That also
what is it, what is,
No, no,
what is it going to serve?
It may sometimes serve, my lord, I'm saying with my lord.
That is why we have to leave the will of
No.
the intention of the
No,
request.
intention is clear, my lord, I want
No,
protection
no,
of everyone, I am not.
what your prayer is okay, but with the facts that has been just,
But how do I
rattled
get,
out.
but there is an observation against P1 now, that is the.
No, no,
on the
that is
face
all
of
right,
my lord.
that is all right, but then we will have to see it in its perspective alone. I mean,
Your
because they,
lordship may issue notice at the moment, your lordship may not, I may decline my.
Keeping the
inquiry.
maintainability issue open.
no, no, there is nothing here. I don't think we can, I don't think your thing can be allowed. Why don't you withdraw and file a fresh? If you want,
Your lordship then give me the permission for on.
if you want, you can do that, I think.
I
Yeah.
don't disagree, Lord. I have no objection.
Because you have got the liberty to do that, because as of now, it is, I mean, it's, the ultimate decision.
Will have Punjab and Haryana case also. Ultimately, relief was not granted. But these observations
Correct.
were set aside.
No,
So,
no.
my lord, what I am now, my lord, I can see what is staring at me. My lord, because we are here before your lordship is because of a practical problem that will arise tomorrow, day after day. I am not trying to interfere in their process. And the government can take a decision in its discretion that we don't want to, there is some element of change, so why should we get into a project? But this is T1, I'm saying, if I have to challenge this order. I can't.
You have to challenge the order after making amendment of the writ petition. You have not even, the respondent, like the AG said,
No,
there is no department of,
If I today want to challenge only the 54,
Ah.
these observations, then the selected candidates, if I'm not really assailing, I want these observations not to come in my way in other projects who are P1. Then I have to challenge my lord 54, and if I challenge 54, there is no necessity to. Today also it's like
please look at your post title.
my
You see, please look at 54 first. 54 is by the Assam Urban Infrastructure Investment Program.
Right.
Okay.
Right.
And this is by the South Guwahati East Water Supply Project. Now, what is the department here? This project director is from which department
this is all project of the project.
of the project? Which
And
department?
the
is it?
tendering, if your lordship sees page 65.
Okay, anyway, right.
That your lordship, your lordship would see.
So you want me to issue notice?
It solves many a problem, my lord.
Okay, right. So we'll issue notice.
Only note.
Only notice. Heard, Mr. Leonard Senior Counsel, assisted by
And this
SD. Also heard Mr. P. Saikin, the Leonard AG Assam. Just take this, the petitioners are agreed by the impugned. This one, huh? Just take the synopsis. That's all. And then they say, issue notice, returnable in 4 weeks. Mr. S. Bora accepts notice on behalf of. Can you accept notice? Their department.
Department is not there.
There's no department. So where is who? That is not. Which department are they going to?
Let them notify it, Lord.
Correct.
Correct
Now, who-
department
they-
should be there.
They cannot accept notice because the departments are wrong.
the way. Well, but
There is no Guwahati Development
your lordship may
Department.
then issue notice to 2 and 3, permission to correct the nomenclature.
No, you have to file an application. That is as per the
That
notice.
liberty to file that application.
That on that day, Lordship may be free speech.
Your lordship
Not
may,
today.
my lord.
Let them correct that party. At
Correct,
least
correct,
respondent
correct.
number one.
Yes,
And I don't
Three are the
represent 2 and
tendering
3.
authority, lordship may issue notice to 2 and 3.
Okay, right. Issue notice to the respondents
By
number
registered
2 and 3.
By registered.
But yes, sir. Returnable in 4 weeks. In as much as the Mr. D. Saikia, learned AG submit that there is no department, but comma Guwahati Development Department in the government of Assam. Petitioner will take steps for service of notice upon the respondents number 20 by registered post within 3 days. List the matter after flowing.
Permission
Lordship,
to move an application for the.
That
and
is-
with
that is-
and your lordship, so please. Deeply obliged and sorry for taking so much time.
No, I wanted to learn a little bit.
Lordship, so far as 2 and 3, we can appear, Lordship. My.
Okay. Acha, then you write, Mr. S. Bora accept notice on behalf of respondents number 2 and 3. Then that Mr. Saikia's submission is, okay?
Deeply obliged,
No step, not it.
Highly obliged.
deeply obliged, deeply.
Do you want this back? Is that when?
For your lordship, it's my.
May I please subscribe? I make a law. Subscribe item number 10.
Yes.
Have already been for while called for. I was in some pain, so it is urgent, so subscribe may kindly take place. Today,
No, now I don't have time. I've got some program.
item number 10.
Next.
Subscribe
We'll see. You're not just barging here as and when you want. Just wait. Yes,
I am challenging the imposition of the recovery of my lord data amount from the petitioner, my lord. What my lord is importantly, my lord,
what is wrong?
there are two schools, my lord, operating separately, my lord.
Ah, yes.
There are two schools operating separately, my lord. In 2018, my lord, petitioner was asked to deposit 13 lakhs, my lord.
Huh?
Petitioner was asked to deposit 13 lakhs in odd amount. Petitioner write letter date for 12/9/2018, my lord, applies the authorities that there are two schools operating, my lord.
Same name.
Same name.
Ah.
Thereafter, my lord, authority issued letter to Porta schools, my lord. And requiring the petitioner to furnish the details of proprietorship for the school. And the petitioner requested the authorities, my lord, requested the authorities to make a typical inspection to unearth truth, my lord. To find out the truth, my lord.
So,
Find out the truth, my lord. There are two schools operating that.
so you are saying that you are not liable to pay this amount.
Yes.
It pertains to another school of the same name.
Yes.
Is that other school made a party here?
That's not my part.
You make a party. You make that other school a party.
Right.
We do not know. You make that other school a party.
But from the letters of the authority appears that
Mr.
I
Counselor,
will make.
unless you make the
Yes.
party, we do not know. Because you are saying that the other school has to pay, not your school. Let the other school come and say,
Right.
yes, they have to pay.
Right.
Then at least all the parties are here. Then you withdraw with,
withdraw with liberty.
yes,
Yes, ma'am.
Mr.
RS
R.S. Mishra, learned counsel for the petitioner, submits the appraise that he may be allowed to withdraw the writ petition with liberty to file a fresh in as much as he wants to implead, he wants to implead
once
the Springdale, they want to implead another school which has the same name as the petition. And that's all. Whether the petition is considered allowed, the petition dismissal.
in 13%.
What is to be done here? Makijai proceeding.
They have to pay lordship. Take up this matter finally after some time. Next. 40.
Yes,
Payment of contractual bill. Normally you have to file application.
Mr. B, over, he's not here, what to do? Where's Mr. B, over? After some time, next.
50.
Yes. Your affidavit.
Yes, sir, we have filed our affidavit.
I have filed, but I do not have it in the record.
Oh.
What does it say?
But they have said
Is it
that there is
filed-
nothing
filed
adverse
yesterday.
against me, my lord.
So?
Just the two paragraph I am reading it. Prima facie, however, it appears that the due process is not being followed in the sub-register office, wherein, my lord, I was working at the deep register. The office of the undersigned had also received several verbal complaints about the demanding of bribe by the office staff of the sub-register. Moreover, the self-admission by the sub-register that is Tapan Roy, a deed writer at the sub-register office, was interfering in official work with malafide intention also needs to be examined carefully. So, my lord, how and in what manner I was interfering, it is nothing in the report. Secondly, my lord, in this last paragraph.
Anyway, I think let the affidavit come.
Lord,
Right. Mr. S.R. Barwa submits that affidavit has been filed. Affidavit in opposition has been filed. So sub-registry place the same on record. This is the matter after the vacation.
may I pray for a date?
Give a date, give a date. Item?
The admitted matter can be disposed of. The providing the admitted amount may be paid within a particular time. For the balance amount, may be allowed to take a.
Yes, any affidavit, what is it?
They have given an instruction.
Where is the instruction?
Lordship may kindly see that the order dated 23/9. Yes, provided. The admitted amount may be paid.
Number 7.
Para 7.
Yes.
You file an affidavit. Let you file an affidavit. Mr. C. Sharma. Prays for 2 weeks time to file affidavit. In person to the instructions received by him by letter dated 5/9/2024, issued by the executive engineer PWD, bracket RNB, half long division. This is the matter after 2 weeks.
I'll take the instruction.
Huh?
I'll take back the instruction.
Yes, yes,
The first week of November.
I'll list the matter on, give any date, fill the date. We'll give the date, 5th November.
Supplementary motion with 26.
26.
26.
Right. No one appears for the petition on call. The petitioner has prayed for setting aside the letter dated 26/9/2019. Yes, what?
We are trying to become like.
Okay, wait, whatever said? No, before that, after that. Which states as follows? Huh? You take it at page 124 from subject to, from 2 to, huh? The petitioner has thus prayed for. No, on perusing the agreement executed between the petitioner and the Bodoland Territorial Council, bracket, it is seen that
My lord, sorry to interrupt.
clause it is seen that as per the terms of agreement, the period of agreement was for a period of 12 years from the date of execution of the agreement, that is 30/09/2019 2000, which could be extended from time to time on mutually accepted terms and conditions.
Lordship, here, RP Bora is handling the matter, she is on leave.
It's okay. Yes, he's here. He's here.
He's on leave, man.
He's here.
This matter, with receive instruction. Your lordship will just grant us the liberty, we will approach the authority in case any further demands. We are withdrawing the with our liberty.
Okay, Mr. Anthony Chaudhary, Senior Counsel, assisted by Mr. K.K. Barwa. Please that he may be allowed to withdraw the writ petition with liberty to file a fake. So, he further submits that liberty may be given to the petitioner to approach the authority with regard to his grievance contained in the writ petition. Mr.
If any.
Huh?
If any.
If any, Mr. S. Barwa appears for the PTC. On the prayer of the petition counsel is allowed, the writ petition is dismissed as withdrawn, with liberty.
Timely to be
Any date, Lord.
Okay, Mr. P. Gogoi submits that instructions have not been forthcoming. Accordingly is granted 3 weeks time. This is the matter.
Any date, Lord. Any date may fix, Lord. Apply.
thank you to order.
Tell one of the steno, Kalpana is free now.
May I please, Your Lordship?
Item,
19.
yes. Mr. Bora,
This is regarding forest department. The chart has been given, my lord, but I have not sent the hard copy. Check it out, my lord. This person, chart has been given that entire list, my lord. I have checked it out, my lord. This is come on WhatsApp, my lord. That hard copy I have not received it, my lord.
what, that BTC?
BTC, my lord.
It's again BTC.
BTC, my lord. It is regarding this bill payment.
Where is the chart? We
No,
have
no,
got
this
the-
is not, it is forest department.
Huh?
It is forest department. So lordship will post it after vacation when I will pick up that entire chart.
That's the last of still already.
Last order also same thing we said.
The chart has been, I have received it, my lord, but I have not seen the hard copy on the mobile WhatsApp. I have.
You give us, you give it to him, we'll see it now. You WhatsApp, you send one message to him. If your phone is with you in your pocket,
Lord,
you send it.
I will, man.
You send it now, we will see it together. Let us see, where is his name? What is the petitioner's name?
MS Mullen Enterprise.
MS Malina.
Very
Malina Enterprise, Malina.
Chart consists of
Malina. Malina Enterprise, MS Malina.
this is the PDF one. PDF. 140 names are there.
Oh, that's not much. Not like that PTC 1988.
take time because if the work order has been given, it is compare. Mention of the work order has been given.
Let him appear.
Well, nothing, in the meantime, I will verify my love.
You're not doing anything. Took time last time. Heard. Mr. Devi Ahmed, then counsel for the petition. As well as Mr. S. Bora, then counsel for the respondent number.
And it is with after number 2, my lord.
Respondent number 2.
Order.
The present contempt petition has been filed alleging willful and deliberate non-compliance of the order dated 24/11/2021 passed in WP 2950/2021. Wherein this court had directed the respondent to verify the claim of the petitioner for non-payment of his contractual dues. In terms of the guidelines laid down by this court in Tamsir Ali and others, or State of Assam and others, reported in 2008 4 GFC 1. Despite the despite the contempt petition having been filed on 27/6/2020, no action has been undertaken by the respondents still. Time and again, this matter has been adjourned for obtaining instruction and on the ground that some more verification was required. So, this court, this court is of the view that is of the prima facie view that when is of the view that as nearly 3 years have elapsed from the date of the order dated 24/11/2021, passed in WPC 2950/2020. The respondents are deliberately flouting the orders of the court, the same which have to be dealt with. Accordingly, the respondent number 2 is directed to appear personally in this court on next week. Give a date on Thursday. Tell him to get ready. I'm going to frame charges against him on 3rd October at 10:30 to give reasons as to why the order of this court passed in the year 2021 has not been complied with still. It says Bora can communicate this order to the respondent. 20.
Okay, the cases being by RP or
Huh?
This case is being handled by RB Bora, who is in the metro. Take it up.
You're right. Lordship, but already as per last operator lordship, already this matter listed lordship for payment. As per last. Submit that serial number 505. He is bereavement, Mr. Council, Mr. R.B. Bora. He's there. Her name is there in the last day, in the last 4 days, on the date subsequent to that. He's in bereavement. Ms. R.B. Bora, adjournment prayer has been made on behalf of Ms. R.B. Bora, learned counsel for the respondent, on the ground that she is bereaved. Accordingly, let this matter to the.
Okay.
21.
Okay, no, RB Bora.
Same.
22. 22 also.
Let me see. Same. Okay.
We have filed our affidavit, running page 39 of the affidavit.
My lord, on the last occasion, my lord had asked us to bring instruction with regard to the status. My lord, this is an instruction, my lord. My lord, they have not applied electricity connection as per the provision.
They have not.
They have not applied for the electricity connection as per the provision of 4.3.2. My lord, and my lord, they were
4.3.2.
4.5.2, my lord.
4.5. What does 4.5.2 say?
So there's a format of regulation where they, because my lord, this is a committee. So the committee cannot apply for all the households. So every individual has to apply separately for the electricity bill first. Second, my lord, what has, where we went for the inspection of the site. It was found out that most of the people, house of people, by the means of booking and by means of the other method, have been illegally been taking electricity connection. And this is, my lord, we have signed and we have given this as per the instruction, as my lords on the last order, to come up with an investigation of site and everything. And it's been clearly written here, as the earlier network, along with the transformer, was completely dismantled by the district administration during the eviction process, and new electric has been to be constructed for providing temporary power supply to the members of the petitioner committee. Here, I would like to inform you that on 24/8, a team of officers of ESD went for anti-theft drive at Yusuf Nagar along with Satgaon Police Force and found that many people in that area were availing electricity from a distant transformer illegally by means of booking, and I'm also extending LP network, very hazardous. Immediately, our team along with police dismantled all the illegal connections which were used unauthorizedly for availing electricity as per norms of the PIT.
That's it. I should be given the opportunity of placing my, since I have been asked to place the, file the affidavit, and I have filed. Lordship, page 39, running page 39 of the affidavit. There's an application accompanied by the copy of order copy of this honorable court, and the list of the consumer lordship who, after depositing considerable amount to the department, has availed the connection. Given the list, lordship find that at page 45, the list were given. The entire list were given of 111 individuals, lordship, along with the bill copies, lordship.
These bills are, how many bills are here?
Here, list were given. Basically, the list were given of the and lordship may please to see that this has been duly acknowledged by the department on 22/7/2022.
Where?
And then
Which page?
page 39 of the affidavit, running page. And thereafter, lordship, that they are referring that the power, and page, again, lordship, page 58, may kindly be seen, lordship. Thereafter, after the contempt proceeding was done, lordship, in a query by this honorable court, if the petitioner were asked to visit the office, and lordship, I'm reading the contents of page 58, lordship. Subject application regarding the transformer for reinstallation of electricity in the Yusuf Nagar area based on ongoing case, Honorable Guwahati High Court, as per discussion with the Honorable as these are on 25/4/2023. Here, Lordship contents. With due respect, I humbly submit that we are the President Secretary of the Yusufnagar Union Committee under the jurisdiction of your office. On the basis of the ongoing case, the Honorable Guwahati High Court regarding the reinstallation of electricity, the said village, we had a discussion with the Honorable as these are on 25/4/2023. In that discussion, sir informed us that residents of village would have to personally bear the cost of transformer. It seems impossible for the residents of the village to purchase a transformer. Therefore, we request you kindly to provide transformer from the department to assist the poor resident of the village. This is the representation. And this is again duly acknowledged. The next page 59 is the vernacular, Lordship is given in vernacular. It's been duly acknowledged by the office, Lordship. That is 26/09/2023. Page 29, vernacular page, duly
This is
acknowledged.
the council.
And the Lordship, the transformer which they are referring that it is dismantled. Not at all. I have given the photographs, Lordship.
My lord,
Is it
please.
clear? It's a working condition. Now the problem is, Lordship, they are asking, they are not denying that they are not giving. I'm taking their step for a moment, Lordship. What is the problem? They are asking to purchase a new transformer.
They cannot. I just wanted to know what the answer will be. You see, all of us take electricity connect.
Hello.
You in your house, you take electricity connect. No one asked you to pay for the transform.
No, madam, may I just submit?
Okay.
They are asking.
I don't think every one of us live in our own house.
Madam, may I
You think what are you asking the
No,
villagers
my
to
lord,
buy?
we have
transform?
not, my lord, can they just produce any, my lord, may just first, my lord, I'd like to take you to the, my lord, the effect
Just
of it.
just to controvert
May
this
I
sort of
just- may I
allegation.
just submit here, my lord.
They are placing all these
Just
things.
a minute.
May I just, let me submit, my lord.
Please do not disturb him.
My lord, may see,
Yes.
my lord, the order of page 44.
Yes.
The members of the petition committee will accordingly furnish details, particulars to the authority concerned about electricity being provided into the earlier before the eviction drive was conducted. Before the eviction drive was conducted, the interim order passed earlier for the ensuring that the member organization may not be divided necessarily during the pauser of the eviction process. Now, my lord may see the bills which were at page 24, page 55, 52, 53. These are bills of 2016. These are 2016, my lord.
Yes.
So, my lord, these are of bill date 2015, first one, second is 2016. Then, my lord, it was of 2012. My lord, then of 2016.
Yes,
then of
where is the latest bill?
Lordship, the basic contention is that whether list were given or submitted or not, Lordship, as per in terms of the previous connection. This is the list, Lordship, page 45.
Have you submitted your affidavit?
The
yet?
content
I'll
of
submit an
the-
affidavit, my lord, because we have received a copy yesterday only, my lord. Yesterday only we have
content of
submitted the
this
copy.
Lord.
I'll bring out
Bona
my
fide
instructions
claim,
later.
Lordship. Electricity be restored, Lordship. Bona fide claim. They are unnecessarily harassed until the decision, Lordship. When there will be a final decision, yes, they seems to be encroachers, then be, but it's where this order been passed in the year
Just a
2000.
minute, madam. It is not that just because you carry on speaking that you're influencing the court. There's a certain limit, certain decorum should be maintained.
Yes,
When was the electricity disconnected?
My lord,
Electricity was disconnected when?
in the year 2013.
2013?
No,
no, it cannot be 2013, my
no,
lord.
no, Lordship, disconnected. Yes, sir. But the disconnection only repetition was papered, Lordship. And,
Your writ petition is of 2021.
2021, my lord. It will be,
So do you have your electrical bills of 2020?
to that effect, I have to,
You have to produce.
get an
Let us see if you all have been paying electricity bill. You bring your electricity bills of 2020. All of you. All the petition.
Lordship, I have to get the instruction first of all, from which period the electricity has been discontinued.
No, you just get the electrical bills of 2020. All the
Lordship,
petition-
if it is prior to 2020,
Okay, whatever, you give
Whatever, Lordship.
2019, 2020,
Yes.
but every month there is an electricity bill, madam.
yes, sir.
In fact,
Before the disconnection, before the disconnection,
actually, just before
Yes.
after
before the
disconnection.
disconnection, yes.
give me the
take that
electricity bill.
instruction. Let it come after vacation, then Lordship.
Yes.
Please.
The petitioner's council pays for time to produce the electricity bills of the members of the petitioner association.
Before disconnection.
In the meantime, no, this is the matter after the vacation. In the meantime, it's the
SP Sharma.
SP Sharma for the APDC for the respondent number. No, for the respondent.
Oh, yes, but contempt petition, madam.
Huh?
My lord, for respondent number 1, my lord.
1,
1,
Yeah.
2, and 3.
1, 2, and 3 shall file their affidavits.
Also, ma'am.
Just submit that, shall file affidavit on behalf of respondents number 1, 2. Yeah.
Also, in this petition, the challenges twofold. Firstly, the challenge is with regard to non-consideration of my application for remission of revenue. I have been settled with a fishery for a particular period of 7 years. And secondly, the challenge is to Pakija notice that has been issued. The facts are like this, Lord.
So what is to be done now?
Look, this can be disposed of I have a limited prayer right now. My applications are pending since 2000. There are 3 applications, one of 2013, one of 15, and one of 19.
Yes.
So those applications have not been considered. Nothing has been done. And
But then once they start Pakija proceedings, it means that
proceedings,
impliedly they have rejected your application.
I have not been communicated anything.
How we are telling you?
Pakija proceedings, the notice was state notice. The choker's notice that was issued. That was.
You see, where is the law which is that your representations have to be decided and communicated to you?
If I make a prayer under Rule 16 of the.
You just tell me, yes. As per his application.
You amount to not
No, Mr. Kaushik, please listen. His case is that his applications have not been considered.
Yes.
Those 3 applications. You please find out whether his applications have been considered or that whether that they are not being considered and
Whether they
that
have been rejected, considered or not considered at all.
whether it is impliedly rejected or something like that. Find out, give us that.
My humble submission is that representation also have been filed before the government. They have filed before the deputy commissioner for emission.
Okay.
Because amount due is 1,93,000. So the government has the power for emission, but he has approved the deputy commissioner.
The deputy commissioner doesn't have the power.
As per Rule 16, the deputy commissioner is the authority.
Not that amount.
What amount?
That amount is 1,93,000.
So why the deputy commissioner cannot decide?
Some I don't
No,
have
but,
some certain.
May I read the Rule 16? Notwithstanding any provision in the condition of the fishery lease, remissions of revenue, fishery revenue may be granted in exceptional cases by the deputy commissioner up to the extent of rupees 50 in any one case, and by the commissioner of place-
Rupees how much?
rupees 50, those are the
50,
rules of 1950. And by the commissioner of place division up to the extent of rupees 500 in any one case, provided the officer authorized to grant the remission is satisfied that the refusal of remission will cause serious hardship to the lessee. The remission of revenue to the extent of more than rupees 500 in any one case will require the sanction of the state government. The sanction will have to be taken by them. How will the lessee take the sanction of the government? I will naturally approach.
Directly they can approach before the, normally we have seen cases, directly they approach before the government lordship.
But what about the Bakija case?
Because my entire case is that I was given the fishery, handed over the fishery in 2012. But after handing over the fishery, I came to know that some other persons were illegally occupying the fishery and doing fishing in that. So I filed a case before the civil suit for right title and possession. The case, the judgment was given in my favor. Still after that, the fishery I could not fish, or not even for a single day. So that's why I had made repeated applications. In fact, in 2018, I handed over the fishery to the government, saying that I have not been able to fish, not even for a single day. So in those facts of the matter, my applications ought to have been considered, but instead of considering, they had issued the Bagate notice to me. In those circumstances, I was going.
Your affidavit is here.
Yes, in para 10, we have said that no records of handing over to the government is found in office record. There are 10 of our affidavit.
So,
I can paste the document. Never will take up page 42.
Huh?
42. The document by which I had handed over the fishery to them. This is the translated copy, my lords.
this is your letter, they are saying that now this is a disputed question of fact. They are saying that the document has not been submitted. Now what is
My lords, the vernacular, there is a receipt of the deputy commissioner with the seal. At page 45, my lords. Down below, my lords will find the seal of the office of the deputy commissioner and it has been received.
You bring the record.
2018, Lord. Let them produce the record.
You bring the record. This SR Barwak has produced the record. To ascertain as to whether the petitioner had handed over the fishery to the
government.
To whom? To whom?
I had to the government. No.
To the government. Deputy commissioner is not the government, by the way.
No. Deputy commissioner is not.
Then to who did you hand over?
We handed over to the government.
Government means which officer?
Because we had written to the deputy commissioner. We had written to the deputy commissioner. So the deputy commissioner to the government. Document that 42 lordship. Vernacular is 45. That is for a prayer for remission. There is also a statement that we are handing over the fishery from now. It is not the way, Lord.
Yeah, why you? You're very smart. Telling that this is the handing over document, page 42, and I cannot read it because it's in vernacular.
Plus, there is a statement here that in the vernacular that we are also handing over.
No. You said there's a document. Where is that? You said there's a document. Where's the document handing over?
Because
45.
45 is the vernacular. Type copy is 42 lots. Type copy is 42. Type copy is 42. Where subject is also written as application for remission of revenue with regard to so and so.
Is there anything regarding handing over?
Yes, there is one. We'll take up the third paragraph of that, page 42. The last line, Malaj.
Yes.
Therefore, on 5/5/2018 a discussion was held among the members of the committee in the general meeting, and as per proposal number 3, the committee decided to hand over the 34 number mean mahal to the government. The committee also requested the government in proposal number so and so to recover the remaining government revenue from the accused parties.
It decided to hand over. Yes. There's a difference between. It's like saying I'm deciding to climb Mount Everest tomorrow. Does it mean that I will climb it tomorrow?
We had also submitted. We have stated in our affidavit that no such record has been found regarding handing over the position of the fishery lot. But along with this application, we had also submitted this decision of the committee. There is also an explanation. All are disputed facts, okay. All are disputed facts, okay.
There's this matter again on first. Make it after the meeting. Here it is. Yeah.
Item 24. Can a date be fixed with this matter?
Can you, on which date Mr. S.R. Parwa shall produce the report? He'll produce the report.
Not after vacation.
After vacation. What is the date?
Okay. All right.
Item?
Review.
Yes.
Alert,
But,
Can it be after the interacted?
okay, on the prayer of the parties, please the matter after the vacation. By the time the period should end, I think, or what, no. There is, Ram Pradhan,
Because of, due to, for contempt, my lord, I have been,
Yeah.
I have, proposed.
you've already joined. Okay.
I have filed in complaint, in compliance of that.
Okay, okay.
Otherwise, I am ready, my lord.
You're ready. Extremely ready. Okay.
Complaint.
Was it? We have been directed to place the updated extraction process.
Yes.
The application process. Was clear. Okay.
Retirement date.
Process.
Nothing is happening.
What is section after vacation process?
Okay. Mr.
Hey, go ahead.
A. Gogoi. Appearing for the state respondent has submitted a letter dated 24/9/24 issued by the Deputy Secretary to the Government of Assam Labour Welfare Department. Is to the effect that further consultations with department is ongoing and the outcome is expected to be brought before the cabinet again for a final decision. When? After 10 years, 20 years, what is the matter? After the vacation. Okay. To enable the petitioner, to enable the state respondents council to obtain up-to-date instructions. Yes. What is your case?
Is it tender money?
What do you want? Get up there.
But this, I have challenged the eligibility criteria having experience.
No, you see, the problem is even the, you have to counsel. You should be there at time. You know, come as you want.
I'm extremely sorry. I have made apology.
Yes.
But this application is directed against the eligibility criteria. Eligibility criteria.
Page
Your lordship 23, your lordship
23.
is a NIT.
Yes.
23 plus 4.
26 plus 4 years.
May I read? The bidder should have experience in transportation of rice under
Page 23.
Page 23.
Yes, plus 4.
Oh, plus 4.
It says that the bidder should have digital signature.
The terms and condition of terms and condition. Next.
Page 23 is start with instruction to bidder.
Next. Yes. Terms and conditions. Terms and conditions.
Acha, below terms and
Yes.
conditions. Okay. 4. The bidder should have, yes.
The bidder should have experience in transportation of rice under NFF Act 2013 in Tier 1 and Tier 2 system. Experience certificate for the last 2 years, that is 2021-22 and 2022-23 from competent authority is required. If the experience of a bidder is less than 2 years or new and the other terms and conditions of NIC are fulfilled by him, then he will be eligible to award only one number of CPSS WCCS if he is selected as L1 in financial bid. In such cases, the bidder who qualifies as L2 in financial bid will be awarded the remaining works of L1 grade. Now, by this clause, by this clause, the bidder was separated in two classes. One class is the experience having 2 years, and the other class is your lordship is have inexperience or less than 2 years. And the present petitioner is less than 2 years. But however, is restricted to the petitioner in participating in award contract to the extent of only one number of DPSs. I have been aggrieved by this because your lordship may kindly see 24 clause 10. The bidder should furnish a sum of rupees 1 lakh as earnest money only through online mode in the Assam so and so. Then your lordship may come to clause 22. The successful bidders shall have to
No, it does not say that you cannot participate in more than one GPSS. It does not bar you from participating in more than one tender.
Yeah.
The only thing is that you can be awarded only one.
Only one.
That
Only one.
only one.
But
you can participate in 2 or 3 of them.
yes, lordship, but the discrepancy is
That yes, the others will be given to others.
yes, the discrepancy is that the experience and all the bidders should have furnished EMD and security research. The discrepancy is here.
So what is your prayer?
My prayer is to your lordship is to status quo should be maintained. Your lordship.
Huh?
Say the tender or the status quo be maintained.
What is your status quo cannot be maintained forever. That cannot be a final prayer. That is the interim prayer maybe. What is your final prayer?
Interim prayer is 16 years old. If pending disposal of rules, maybe suspend the NITO.
What do you want? You see, now supposing we say, okay, we suspend the NIT. And then what will they issue?
Lordship,
What part of the what don't you like of this clause? You don't want clause 4, you don't want clause 10. But supposing clause 4 is made to your advantage, that you can be awarded more than one GPSS. Then doesn't that solve your purpose?
Yes.
Then where is your prayer for that? Your writ petition doesn't pray for that. Your writ petition is to set aside the entire tender.
Lordship, because Lordship, in the other district, all the districts have different criteria. If in one district if I eligible, in the other district I have not been eligible. The criteria,
Where is the tender for the other district?
the page your lordship, 46, 66, Kamrup district. There you go, 46 your lordship. Relevant clause is 5, page 50 your lordship.
I don't know what you're trying to say. Yes, what is his case?
Hello?
What is his case? And this is matter on
Yes.
Tuesday. Yes, that same order will. You see, no, you just said this is the matter on Tuesday. You please think of your, you see, please think. Your prayer cannot be just cancel the tender.
Tender. Recall and
What
cancel.
is that?
On what basis? ma'am?
What is the basis?
Basis, yes.
Which part of the tender clause do you want corrected and how do you want it corrected?
State in law, madam, so that
Yes.
lordship will interfere with that condition.
Yes, that condition has to be interfered with.
Madam, no mention of that.
You are just saying that this is bad, but you are not saying how you want it to be done.
And why they are
It's like
against?
saying, I don't like the color of the house, so please break the whole house down.
Not-
Other-
What's
You
the
say that actually the color of the house should not be white, it should be yellow or blue.
reason for
Instead
that?
of that, you're saying break the whole house down. That is the basis. Please understand. You see, you know, now you see, clause 4 talks about if you are, if you have less, if you have experienced less than 2 years, then you can be awarded, if you are selected, you can be awarded only one GPSS. And the rest will be given to L2. So your prayer should be that you should be, this clause should be struck down. That particular clause, not the entire tender. That particular clause, so that if you are selected and if you are having experience less than 2 years, then you should be given, you should be allowed to be given more GPSS as is given to persons having experience above 2 years. Or if you're not happy with that, then you can say that because you are going to be allotted only one GPSS if you are selected, and as you are having less than 2 years experience, then the security, the earnest money to be deposited by you who have a lesser experience should be less, not 1 lakh. 1 lakh for above 2SS for 2 years, and for experience less than 2 years it should be 50,000 or something like that. But you're not saying anything. You're just saying this is this, this is this, and this is there is there is difference in the experience required with other districts. What do the other districts say? I'm not understanding. Please try to formulate. Please think about it. What do you want?
In other districts, the criteria is only 1 year experience, nothing more.
No, make that prayer here. You should say in your prayer portion that there should not be a difference between the persons who are having 2 years experience and less than 1 year experience. It should be, the criteria should be 1 year experience as done in other districts. You make that prayer.
Let the.
You are not making that prayer. You have got to amend your writ petition. You have got to make that prayer. Then it makes sense. Otherwise, you are just saying this. It should be the entire house should be broken down because you don't like the color.
Allow me to amend.
I cannot allow you to amend. You have to file a amended petition. Then we can allow it only. Then you have to file amended writ petition. Or you can do easier way. You can withdraw and file a fresh. That'll be easier. But it depends upon your entire. Because by the time you file an amendment petition, by the time is allowed, I think pujas will finish.
Amended copy that
Let me withdraw with regard.
You get what I said. In your prayer portion, don't ask for setting aside the entire thing. You should say that this clause that is here in your NIT should be set aside. And this clause that is put there in the other NIT, that should be put in. That will serve your purpose. That is what you want actually. But you're not making that prayer at all. Okay, Mr. A. Chowdhury, let answer for the petitioner pray that he may be allowed to withdraw the writ petition with liberty to file. Ms. Yuda appears for all the report. The prayer of the petitioner also is allowed. The petition is dismissed and withdrawn. Come on with liberty of speech. Just make that change in the prayer portion. And then you mention in one of the paragraphs the NIT made in the other district. And then you put your NIT thing which is there. Say that it should be same.
Already mentioned.
Okay, already mentioned. But in the prayer portion you do that. Because it's not making sense otherwise. Otherwise you can make a prayer for setting aside this NIT. But then you'll have to make a second page that when the issue of fresh NIT, this clause should be instead of the existing. You have to you have to pray for setting aside this particular clause at experience number 4. Or to modify it
To,
that
Earlier,
all right.